I'd like to speak briefly about interpretation, especially about morally hard cases. Dworkin discusses in an earlier paper, that is actually a paper entitled Natural Law Revisited, which is useful for various purposes, partly because of two examples in it. The examples are useful because there's an acknowledgement by Dworkin that there can be precedents that are morally unjustifiable, but which will be sustained under the best interpretation of past practice. And there can be statutes which are morally indefensible, but which will be sustained because of the constitutional order. I'll put this as simply as I can. The justice for hedgehogs is important in the present context, in part because of its wholehearted endorsement of the notion of moral objectivity. And that means that we draw a distinction between morally sound principles and morally unsound principles. And morally unsound principles and morally unsound arguments can't justify legal judgments. So we have a problem of how to account for those judgments that flow from sustainable precedents and constitutionally sustainable statutes that are supposed, under Dworkin's theory, to have moral force. That's just another way of saying that law is supposed to be a part of political philosophy. They can't have moral force on the basis of the principles that justify them, because no sound principles or no sound moral arguments are going to be capable of justifying morally indefensible statutes or precedents. So how can we get around this? It seems to me that one way of getting around it, which is suggested, not clearly endorsed, but suggested in parts of the Dworkinian corpus, is to draw a distinction between plausible principles and a subset, a proper subset of those plausible principles, moral principles, which are sound. And we interpret those morally indefensible statutes and precedents, such as in the example I'm thinking, the Fugitive Slave Act of 1850. We interpret them not as morally sound judgments or morally sound injunctions, but as simply legally required. We can then interpret. We interpret not on the basis of sound moral principles or reasonable social goals, but on the basis of unsound principles or misused principles in unsound moral arguments. That allows us to proceed with the process of interpretation. But the result of the process of interpretation of this law, this body that we have identified as existing law, lacks moral force unless we can add something to it. And what Dworkin seems to suggest in both of those contexts, that is, using both examples in Natural Law Revisited, is that there's an extrinsic justification for enforcing the statutes and precedents, not a justification for the statutes and precedents themselves, not a justification, for example, for the Fugitive Slave Act of 1850 itself, but a justification for enforcing it. Now, this assumption that we're going to be able to provide a justification for enforcing morally indefensible statutes and precedent, this idea is not totally implausible by any means. What is implausible, I want to suggest, is the idea that such a justification will generally be available. For example, in the Fugitive Slave Act context, we have to suppose that the virtues of the constitutional order are such that they are relevant to the justification of the enforcement of the Fugitive Slave Act. One might have skeptical doubts about the justification, or indeed the virtues of the constitutional order in 1850, 1851, 1852, and so on, One might have reasonable doubts about the justifiability of the constitutional order. But even if we suppose that there were, indeed there no doubt were, definite virtues of the constitutional order, those virtues wouldn't seem to have any bearing whatsoever on the enforcement of the Fugitive Slave Act of 1850. So it seems to me, and this is quite generalizable, that is to say, given the history of legal systems, indeed, given the history of the U.S. federal system, we would expect to find many such examples. We would expect to find, indeed, I think we reasonably judge there to have been, many stages in U.S. history when the constitutional order was not morally defensible, for example, on democratic principles. Many stages in human history in which we have had legal systems where the constitutional order could not be justified, period. So we are left with a theory that may be able to do some measure of interpretation in morally neutral terms, a positivistic theory, indeed, but not a theory which seems to be capable of generally accounting for the moral force of morally indefensible statutes and precedents. And therefore, we have a problem. My dumb question is, how do we solve the problem?